specifically we are going to look at one of the case which is related to police reform, and that has a specific mention related to bail. Now this bail thing we have come across a number of times in the past. We have heard that bail is an indefeasible right. Now what is indefeasible right? Indefeasible right is something that cannot be annulled, cannot be nullified. So a right that cannot be stopped, right? So being an undefeasible right, bail is something that must be given. Now, to substantiate the argument, I'll also try to take recourse to our constitution. We all are aware of Article 22, right, wherein we have heard how detention, preventive detentions and all are functioning. So clause 2 of that article, it mentions that an individual who is put in remand. Now there's another term called remand. Remand is nothing but kind of you're sent back to custody. So remand is like custody. So so if somebody is in remand or is in custody, right, and has been arrested for investigation without an warrant. So without a warrant, if an individual is arrested, so that particular person needs to be presented in front of a magistrate within 24 hours. Now that 24-hour should exclude any time that is spent in traveling, maybe locating or maybe translocating a person from A point to B point. So if police is doing that, so that small section will be removed out of the total time that is spent. So we have to see whether 24 hours have elapsed or not. So if 24 hours have elapsed, then the magistrate is bound to give that individual bail, provided police was not able to do its investigation in the time frame, is not substantially proven beyond doubt that the individual is not guilty or maybe is guilty, right? So now this system is made to ensure that the accused is not unduly harassed because of unscrupulous police and personals over there. So you can see this bail thing has some relationship with our Article 22 clause 2 of our constitution, right? So isko yaad rakho bas. Let's just keep it in your mind. Moving on, so what is the issue? This issue is related to National Investigation Agency. This approached to Supreme Court against a Bombay High Court order granting bail to an advocate and activist, right? Now, what happened in this case? It is in its bail order, the High Court asked NIA court to decide the conditions of her release, मतलब उसको release करना है. So the activist was given default bail. Now the case highlights the nuances involved in court determining on what basis the individual should be granted bail. Now obviously courts are there as per Article 226, 227 and Article 32 of our constitution as guardian, as protector of, as guardian of fundamental rights. So if there is any breach in Article 22, so if it is found, definitely that that individual will be protected by the court, right? Because fundamental right ki baat hai. Now here again, like I said, this is considered indefeasible right. What is default bail? Okay, now यहाँ सब serious conversation start होता है. Now until now you learned about indefeasible right, you learned about Article 22 clause 2, you learned about how bail is something that is available to an individual as fundamental right as well. Now you also learned about how within 24 hours a magistrate is supposed to give an individual a bail or is supposed to release if there is no substantial evidence to go against that. Now what is a default bail? You may have heard of this Code of Criminal Procedures, CRPC. Now this CRPC has something which is also ensuring the same thing. Now Article 22 clause 2 में जैसे लिखा है 24 hour का window is there within which the individual must be investigated unless proven guilty or unless proven sensitive. That individual is going to be released after 24 hours by a magistrate. Like a magistrate needs to see that person within 24 hours of being arrested without warrant. Now Code of Criminal Procedure also talks about the same 24-hour procedure, right, which is mentioned in section 57. Now here this section 167, it is about the procedure, how that individual is to be worked upon, what are the steps need to be followed, what are the conditions, when the custody or the remand could be increased. So all these procedural parts are mentioned in section 167 clause 2, but section 57 of CRPC, it mentions about this 24-hour window within which an individual, if arrested without warrant, needs to be presented in front of a magistrate. Only magistrate would have right to extend the custody, right? Okay, also known as statutory bail, matlab bail which is based on statute. This is the right to bail that accrues when police fail to complete the investigation within a specified period. ये specified period क्या है? 24 hour. किसमें mention है? Where is it mentioned? Section 57 of CRPC, and is also mentioned in Article 22 clause 2, right? Now, when it is not possible for the police to complete an investigation in 24 hours, that individual is going to be the police produce the suspect in the court and seek orders for either police or judicial custody, right? So police, I mean, this is not an automatic right as such. Police ke paas bhi, there is no power that police can go and continue with that. So police will not get the remand unless and until they have substantial evidence for that. Now, in doing investigation, it might so happen that police could not get enough evidence, but police could not get enough footprints, right? So in these situations, police will have to make a case out of the scenarios, the situations, and if they are worthy of being heard, the court will go ahead and listen to that. Unless that happens, maybe the individual could be furnished. I mean, if the individual is ready to furnish bail, there will be bail given. When the bail is granted, now this has certain differences from law to law. Now one is this, for most offenses, 60 days ka time is like given to the police to complete investigation. If nothing happens within 60 days, matter is bail is granted to the individual if they are ready to furnish the bail, because there are some conditions with the bail. You cannot just go out without informing local police station. You have to go and appear there whenever asked for investigation. You have to be witness, so and pay some money as well. So there are certain conditions for furnishing bails. Okay. However, when the offense is about which might lead to life imprisonment or death sentence, in these situations the available period is around 90 days, right? So from most of the offenses where it is 60 days, it comes to 90 days whenever it is death sentence, a presupposed death sentence on a particular kind of crime, right? Or maybe a kind of imprisonment for more than 10 years. So if these kind of crimes have happened, and for those crimes, if an individual is suspected and is put behind bars, is in remand, in these situations, the police might get an extension of another 30 days over the normal one. So total 90 days. Now, in other words, the magistrate cannot authorize a person's judicial remand beyond 60 to 90 days, normal situation mein. Now, what happens in case this is not a normal situation, right? So the situations vary from law to law. Ordinary law, 60 and 90 day, like you know that now. Now there is something called NDPS, Narcotics, Drug and Psychotropic Substances Act. Now based on this particular act, the remand goes, and this is extended to up to 180 days. 190 ka pura double, right? Now if that psychotropic drugs that we're talking about, if it is found to be in occupation of an individual who is trying to sell it commercially without license, in that case, the remand could be increases to 1 year. So NDPS mein clause hai like 180 days straight, 1 year after that. I mean, it could be extended for another 6 months. Unlawful Activities Prevention Act, UAPA. Now, this is one of the most controversial acts so far, because we've seen that governments use this act, and the sad part of its use is that UAPA has a conviction rate of around 2.5%. So when you have a conviction rate as poor as 2.5%, you can understand that almost 97.5% people, those who have been charged with UAPA, are out of jail without been proven guilty, right? So they have been acquitted. So the point is that UAPA ke case mein, as well. 90 days, default limit is 90 days. The court may grant another extension of 90 days. So 180 days is like cut dikh raha hai humko. If it is satisfied that the progress in the investigation requires some further custody. So even in case of UAPA, an individual may be behind bars for 180 days. Now this is a sad truth that individuals sometimes even spend so long time in the jails that they have even completed the trial for for the supposed limit of time or duration of time, they would be behind bars in case proven guilty, right? So even these situations have happened and UAPA mein bhi hua hai aisa. You may have heard of this latest case, Stan Swamy, right? Stan Swamy, he was convicted of taking part in Bhima Koregaon case in the year 2018. Now, Stan Swamy was behind bars. He could not be released because UAPA was applied, right? And he was implicated under UAPA and eventually he died of COVID-19, right? So you can see that people, those who, he was very old as well. Stan Swamy was very old too. Now here you can see that UAPA in some sense is a little more stringent. Now coming back to UAPA one more time, let me tell you that UAPA is also controversial because most of the states believe that UAPA has some overriding powers that can undermine the federal characteristics, the power, the areas where states need to function. States have sort of sole right to make laws. Even there, UAPA gives power to NIA to go over and assert powers. Let me tell you how. UAPA mein, there is a section 25. So section 25 of UAPA, it gives power to NIA to book properties which are found to be related to terrorist funding or terrorist proceeds. So that can happen, but for that NIA will have to take permission of DGP from that state. Director General of Police of that state, they will have, the NIA is supposed to take permission. But there are some clauses where NIA may not take permission from DGP of the state. Instead, they can seek permission from DGP of NIA and thereby override the requirement as such. So in these kind of situations, UAPA tends to become a little more critical and its application, then its remand structure, that's totally, sometimes it appears that it's certainly not, fulfilling the purpose for which it was made. So controversial to hai hi, but our idea is to learn about how UAPA and its functioning. So I just gave you a bit of added information. I hope you will make note of the sections which I'm mentioning, right? So 180 days is common in NDPC and NDPS, and 180 days is also for UAPA. But in case it is a commercial narcotics use on that possession is found with an individual, automatically that may be extended to 1 year. So remand is very commercial quantity mein 1 year ho jata hai. Just keep that in mind. What are the laid down principles on this aspect? So default is a matter of right, statutory bail, indefeasible right. So this also is coming under Article 21 of our Constitution, right to life, right? Stipulated period calculation. Now, this calculation of period that goes into, for how long an individual is supposed to be either in police or judicial custody. So that thing is a little less clear and transparent. That also depends on, like I said, that police will have to make case out of it. There is an amount of subjectiveness involved so far as the application of days are concerned. So if police believes that a case needs to be made out, right, for the individual to be behind bars for next 90 days, so accordingly the evidences could be made, things could be made, right? So when this things could be made wala point aata hai na, this is where the objectiveness of the application of laws, it decreases. It takes a plunge for unreasonableness. So it is very important that objective, somebody even asked me on Habitat yesterday that objectivity principle of constitution, right? So that's where the laws which are made in constitution, made under the pretext of constitutional rights, made in the parliament, they need to be objective. Unless they are objective, the subjectiveness will erode the principles. Like क्या करने वाले हैं? Ultimately, like X, Y, Z, nothing's happening. An individual who perceives कि ऐसा है, that's going to happen. So voluntary, there is no automatic bail. So this is what I said, that this is not an automatic bail, right? You have to be ready to furnish it. If you are not able to, probably it will not be granted in that case. And police will have to make cases out for that if they want the bail to be extended.
Subscribe to our YouTube channel and press the bell icon on the YouTube app and never miss another update from Civils Daily.